LaPortia Murray.
Your Honor, Sam Bernstein with and on behalf of Mr. Murray.
LaPortia Murray.
Your Honor, we're going to be setting this for exam. We've discussed scheduling and we're hoping for the April 2nd date.
Is she being held on anything else?
Just this, Your Honor.
Is discovery complete?
To my knowledge, yes, Your Honor.
It is.
Yes, Your Honor.
People have their witnesses available. You're not available the 26th?
I am available.
This case has been on for a while. She's being held on a homicide charge, a felony charge.
All right.
There's a number of witnesses, including Detective Since, who's retired. So we're hoping for the second date and hopes that we can get it done on that date.
Preliminary examination will be set in person April 2nd, 2024, 9 a.m. before. Before me. Continue. Thank you. Court calls case People versus Mario Cato.
Good morning, Your Honor. May it please the Son of Before Jermaine Mark, P54352, on behalf of Mr. Cato, who stands to my immediate right.
Your name?
Mario Cato.
I was just retained on this matter. From what I understand, we have to file a substitution and get discovery.
That is correct. We also have a problem with the bond violation.
I haven't seen anything in writing yet.
Can you hand that to him? It's not much. He hasn't gone. Around.
So we got to make sure you get it.
I wasn't aware.
Okay. I'll facilitate and make sure that he does this, Your Honor.
Well, why didn't he go?
He said he wasn't aware, Your Honor.
From the time of his arraignment, he was put on standard supervision and hasn't gone over.
No, Your Honor, I'll make sure that he does today. I'll walk him there myself.
We can provide the transportation if he doesn't know how to do it.
I'll be more than willing to help him. He's a law-abiding citizen, Your Honor. This is his first contact with the criminal justice system.
Your Honor, the request from people, if the court would entertain, it would be that if he go test right now, we get those results, we come back and we determine what to do with bond violations.
He's willing to do that, Julie.
You're gonna come back clean?
Yeah, I haven't smoked. So.
You come back with,
Can we, I just have 1 second, Your Honor.
yep.
For transparency, Your Honor, he said the last time he actually used was the date of the arrest. Other than that, he's been,
When the date of the arrest?
yeah.
Which is what date?
The beginning of March, Your Honor. You were supposed to do.
If I send you over for an ETG, you had anything to drink recently?
No. No, Your Honor.
The 3rd.
Yes. March 3rd.
Pardon? So when at the beginning of March were you using?
I do not remember the exact date. I suffer from TBI, so my memory isn't the greatest, and I don't have anything right on me right now. to go back and look on, but it was it was at the beginning. It's like 2 or 3 weeks ago, more or less. And when I got out of jail, they said that I thought I was supposed to drug test today. I didn't know I was supposed to drug test before. Your Honor,
So you knew you were supposed to drug test?
I thought that's what I was supposed to do today.
He thought today was supposed to be the first test, Your Honor.
Take him over to community corrections, get a test on him, let him know he's coming over, and then come back and we'll decide what I'm gonna do with this bond violation.
Okay.
Well, you went over, took a test, and surprise. I don't know what you are smoking, but it's no good. It's all negative.
Yes, around people are also in receipt of that test showing the defendant is currently negative for all drugs, including marijuana. The good baseline, so if he comes positive later, we'll know that that was false for Raymond use.
Yes, okay. So counsel, you wanted an adjournment.
Yes, Your Honor, or
What date did you,
a couple weeks out would be great.
couple, 28th work for you?
I'm actually out of town that week, and then the next week I started a trial downtown.
Sounds like four.
Well, you start the trial on the 4th.
On April 1st.
Okay, you saw you that week. So April 11th, will that work?
That should be fine, Your Honor.
Probable cause conference, April 11th, 2024, 9 a.m. Defendant's bond will continue. I'm signing a new order regarding your testing, and I'm placing you back on standard supervision with urine testing once per week.
You understand?
Yes.
You understand?
And I'm gonna have you, so that we're all clear, I need you to sign off on this order,
Thank
young
you, Your Honor.
man. No, I crumbled it because it was.
Today's date. To sign.
Did they do it? Did they just test you, young man, or did they do an intake on you when you went over?
He has an intake form we're actually going to take back now.
Good.
Okay. You know the form that you were filling out.
To be rough.
This is the third month. 3/14. 24.
All righty. Bond will continue with that condition. Thank you. Thank you, counsel.
Thank you.
Edward Lucas on behalf of Robert Bigham.
Your name?
Robert Bigham. Your Honor, today's time and date set for probable cause conference. I was appointed 2 days ago. I did get the discovery yesterday, and a lot of videos came in yesterday. I have not had the opportunity to review those with him. I'm asking for a 2-week adjournment.
Any objection?
The adjournment that I would like to address bond.
Probable cause conference will be adjourned to March 28, 2024, 9 a.m. as to bond.
Requesting either revocation of bond or to renew our request for 100,000 cash surety in this case. The revocation request is we have received a community corrections violation. The defendant has never appeared at community corrections and has failed to ask for anything. So on that note, I'm requesting revocation of the bond and an immediate remand. However, in addition, at the time of charging this case, and before I go on, do you have the community corrections?
I do not.
I received it yesterday, Your Honor.
I sent it to defense counsel and I can forward it to.
Ann.
Provide you my copy.
Go ahead, Ms. Hughes.
At the time of charging this case, my office requested a 100,000 cash surety bond. The defendant does have an extensive criminal history in the sense that he has been convicted Starting as far back as 2000, he was convicted of misdemeanor drug possession. In 2003, he was convicted of domestic violence. 2004, he was convicted of fleeing third. That's noteworthy here because this is a fleeing third case as well. In 2008, he was charged with but not convicted of domestic violence third offense. In 2011, he was found guilty of resisting and obstructing of a life offense of carjacking and another carjacking and an attempted. That is his most recent, those are his most recent felony convictions from 2011. From that case, he was sentenced to 2 years to 5 years in the Department of Corrections. This is a fleeing and firearm case now, and his guidelines on this case are 14 to 28 months without a habitual case. But at the very minimum, it doubles the 28 map that I believe is 59. I think that's correct. In this case, the defendant was driving erratically, so erratically to the point that he at one point was driving on the opposite side of the road into oncoming traffic in an attempt to evade the police. His speeds were, as far as I can see from the report, as high as 50 miles per hour in a 35 mile per hour zone. He put not only the police in danger, but also the community. Then, in addition to that, as you can see from the other charges, after the police, so at some point the police did have to terminate the word. Thank you. Chase pursuit. Thank you. Team effort. Because of how dangerous it was. Instead, they continued to follow him at a safe distance. He once he stopped the car, he got out of the car and continued to flee from the police on foot. While the police actually yelled at him, he was going to be shot. They were going to shoot him if he didn't stop running from the police. They were able to take him into custody, certainly without him continuing to assault and obstruct them first. Then, while they were inventorying the car that he fled in, they recovered a magazine from a handgun. This is a convicted felon. Multiple times over. They knew, based on their experience, that typically where there's a magazine, there is a handgun. And they discovered a handgun on the route and he fled from them. In addition to that, however, they also found, they also suspected, that he was under the influence. So we are waiting for his blood results still. The blood testing is still in the lab. And then, as you can see from your charges as well, he was in possession of a baggie that had some type of white powder in it. This was something he left behind in the deputy's vehicle, tried to. Your Honor, I'm requesting either just straight revocation, bond denial, or his bond violation of failing to ever go to community corrections, or I'm requesting the $100,000, which was already requested in this case. Thank you.
Mr. Jervis.
Your Honor, he was arraigned on February 12th. He did post his cash or surety on the 18th of February. He had a PCC on 2/22. Everybody was in court the last hearing. That was not addressed regarding his testing. He obviously got out. He didn't go to community corrections. He was unaware at that time. No one reminded him on the 22nd. I got the bond violation yesterday at about 4:10. I called him and told him to go to community corrections immediately. Got back on the phone with him, told him they closed at 4:30 to show up at 8 in the morning. He was there 8 in the morning to try and do an intake. They would not take a test, or they would not do an intake this morning. He was told due to the bond violation. His mother is here with him today. He's obviously showing up to court. He's not driving. He was in his mother's car. As far as, minimally, I don't know the full facts of the case. I did start reviewing some of the video. I do understand that there may be another occupant to that vehicle. I'm not too sure on who the actual driver was of that vehicle, be with 2 occupants. So regarding, I'm asking that the bond remain. I'm asking that he report to community corrections today, allow him to do the intake, and continue on a testing.
Why didn't he go test?
I don't know. And nobody, and the other thing is no one reminded him the last time that was in hearing.
Okay, but he was told at arraignment to go test.
I understand. He was in custody at the arraignment and didn't post until 40 or 6 days later. So when he got out 6 days later, he didn't go and test. That is correct. And then he showed up 4 days later to his last hearing that got adjourned until today.
In regard to the, we don't know if he's the driver, he's being pursued by the police straight out of the driver's seat. They watch him get out of the seat and they pursue him and they arrest him. So there's no break in that pursuit. I emailed community corrections yesterday asking for a community corrections update on him. Basically, I was looking for more fuel for this fire of this argument. They forwarded me that bond violation. I did not have a copy of it. It looks like the court didn't have a copy of it last time we were here.
We were here on what day?
The 22nd.
Something tells me that it was dated the 21st. I don't know what time it came. It actually is in my file, but I'm not sure when it came down because it doesn't appear that it was here the last time that we were here. When was he released from prison?
13.
2013.
2015, his parole is now expired.
Pardon?
His parole's expired.
Send him over there right now. Is he going to test clean?
The answer to that is questionable, but it will probably come back.
Questionable.
Well, I do have the belief that he at least used marijuana prior to the last few days.
And the defendant's bond is increased to $50,000 cash surety. Defendant's removed. Court calls case People versus James Hall. I haven't signed this order on this matter. Your name, sir?
James Hall.
You were represented by Miss Hughes. Was she in contact with you, sir?
Ms. Hughes. This lady?
No.
Oh, the other lady? No.
Have you spoken with an attorney at all?
Yeah, this lady yesterday.
Okay. All right. That was a bad question on my part. Prior to speaking, sir, had you met with an attorney before now?
I don't remember.
When did I? Hold on a second. Was Miss Rushing on this case or?
Initially, she was the first appointed, well, after the public defender's office.
And then Miss Hughes was appointed.
Everyone's fine with that.
All right. I directed her to appear, but Ms. Hughes apparently doesn't believe that she has to. She's already subject to a show cause in another matter because she hasn't dealt with her clients directly before leaving. So we will deal with that. I will sign this order, however.
Thank you, Your Honor. For the record.
I'm not mad at you. Don't worry about it.
Okay, Your Honor. Good morning. For the record, Rita Young, P44626, appearing on behalf of Mr. James Walter Hall, who is present and standing to my right. Sir, would you state your name for the record?
James Walter Hall.
Your Honor, today is the date and time set for a probable cause conference. We'd like to waive, and we've executed the waiver for.
All right. You want to waive your right to a preliminary examination, sir?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yeah, I'm not. Wait.
I know, but I got to make sure you understand what you're waiving.
I understand.
Okay, then just answer my questions.
Yes, sir.
You understand you won't have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
Okay. People also waive their right?
Yes, Your Honor, thank you.
Yeah. Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
As to the arraignment on the information, I waive a formal reading, Your Honor. We stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
Court at 1:30 before Judge Slade Thursday.
April 4th, 2024, 1:30,
Judge, may I briefly-
Slay Thursday.
Oh, sorry.
And tell him to say, yeah, whatever to slay.
Judge, may I briefly address bond?
I want to see that. Go ahead, yeah.
Thank you. My client is 47 years old. He resides at the address that's on file. His bond is currently set at $10,000 cash surety bond. There was some confusion regarding court dates. That will never happen again, Your Honor. I will frequently remind him of his next court dates. He reports that served in the U.S. Air Force for 16 years. He has no prior felony conviction. And so we would ask the court to please consider a personal recognizance bond. He has no objections to home confinement if the court deems that necessary.
Any response from the people?
Yes, Your Honor. I will leave it in the court's discretion. However, the reason that he is in custody is because he failed to appear on December 7th. At the time that he failed to appear on December 7th, we already had a community corrections violation report, which is more so what my concern is how do we know he's going to go to community corrections? He doesn't. But right now, we did not request a bond on this case. So the $10,000 is what we requested at charging. If there could be some assurances that he's going to community corrections, that would certainly make me feel more comfortable.
Mr.
Yeah.
Paul, you have to go to
I-
community corrections. You'll do that?
I can do that. I have caseworkers that could get me there every week or every day.
Caseworkers from where?
Avalon
Housing.
Housing, and I have CMH. as
Are
well.
they, okay, but how are you going to pay for your testing?
I have Social Security.
Gonna need an order.
Okay.
I'll set the defendant's bond at a $10,000 personal recognizance bond. I'll release him. I'll put him on standard supervision with a urine test once per week. Yeah.
Thank you. Thank you so very much, Your Honor.
God bless.
Yeah.
Yeah.
Oh, Mr. Paul, need your signature here, please.
Sorry about that.
Right here.
We're gonna have to go get him. Court call case of the people versus Barrage Scott.
Scott, Mr. Scott, please state your name for the record.
All right. What are we doing?
Thank you, Judge. We were here a couple weeks ago on these two cases. Mr. Scott has a bond violation, which is why he is back incarcerated for allegedly going to a no-go-to area on conditions. Obviously, I met with him in jail. He understands he's put himself in another bad position. He doesn't have a great excuse for it. He doesn't have a great excuse for it. He acknowledges that he messed up in this matter. He's asking the court to let him out again.
To do what?
To let him out again. He is saying that he has applied for Social Security, and if he is not out, he will lose his ability to get that Social Security as well as his disability. And he has a healthcare situation where he needs to get a shot that his insurance has to pay for, that he won't be able to go out and get if he's incarcerated, Your Honor. So he's asking you to consider releasing him back on a personal bond. But what I'm hoping to have done with the case, Your Honor, is just to adjourn the PCC for a couple of weeks so that we can see if we get something resolved on it.
No objection to the adjournment. Probable cause conference, March 28th, 2024, 9 a.m. People's position on bond.
Perhaps a misunderstanding, but his violation is not just going back to the area he was ordered to not go back to. It's that he gets there, he decides to assault 4 police officers. That's the violation. So he was arraigned, I apologize, we'll get these things to you. He was arraigned on February 13th on an RNO and a trespass from Village Grove. He was told not to commit any additional crimes, no assaultive behavior, and no go-to. So he goes back to Village Grove, he commits more crimes, he assaults more police officers, and he goes to where he's not supposed to go.
No, look at me, Barrage.
You're telling me that's wrong.
No.
So now we're here on these 2 cases. In addition to that, so Mr. Easter's done a fantastic job where he does files as well as he does all his files. He has tried to negotiate.
Except the dog way. Wait, go ahead.
He has tried to negotiate this case with me. I've explained to him that I do not intend to make Mr. Monte Scott any offers. He just finished a jail sentence in the fall for RNO.
I know.
This is a person that was sentenced to Washington County Jail for RNO, gets out, it's 2 new RNO cases. Your Honor, his bond actually is low, but I wasn't the one making the request. $5,000 is low for what he's done, but I'm asking Your Honor not to grant a PR bond to the bond as is if you're not inclined to increase it.
Only thing I'll say, Judge, is that Mr. Scott was under the impression that his violation was for the trespass. Now he's heard Ms. Hughes' understanding about the RNO.
He does this every time.
Yes, Judge.
Yeah, no, what are you gonna say?
I'm sorry.
Okay.
Get in no more trouble. I just did.
Mr. Scott, every time you come here, you plead with me, let me out. I usually say no. Then finally I let you out. And what do? You go right. This is not, I realize that you're not being convicted of anything, but I will say this. This is not the first time that you've been someplace, something happens, you're not supposed to go back, tell you not to go back, and what happens? You go back, and you either come back before me on a bond violation, or you come back with a new case because of what you did when you got there. And by the way, other problem that happens is that when you go back to these places, naturally, the police get called. And then you start having issues with them. And
I won't have no issues. I promise you, look, I promise this time, because I just did a year, I won't have no issues if you let me out. I'll do the right thing and I won't go back. Just one chance, because
One chance?
I mean, just this.
Just
One more.
One more chance, please, Your Honor, and I promise I won't go back. Just give me this chance and I'll do everything right. I'm trying to start fresh. Fresh. I just want one chance from you. And
you know what, Mr. Scott?
one more chance.
No. And today, I'm going to tell you no.
Please, Your Honor. Please, because my grandma's birthday is on the 24th and I really want to be here.
I know. And
I don't want to be in jail. I can't. I will do just give me this chance. I promise you, if I go back, I deserve to be locked up, but I won't go back. I won't go back. I won't go back.
Mr. Scott,
I just want
Mr.
one
Scott.
chance, please.
Mr. Scott,
I want to be in jail.
I know you don't want to be in jail, but you got to listen to what we're telling you.
Okay.
You remember I even put you on a tether. And
I'll do that.
I know, but that didn't work either.
I'll do that.
Mr. Scott.
I'll do whatever you want me to do, and I promise you, this time I won't mess up. I won't mess up, Your Honor. Please, just trust in me.
You want me to go get the last 3 recordings when you told me that?
No,
No, because you told me the same thing.
No, but I'm telling you the truth. If I deserve a chance, this time, because I just did a year. Just give me a chance for this time, and I will do everything right. I won't go back to Village Grove. I won't catch nothing. And I promise you, this time it's gonna be the last time I ask. It's a new year.
Oh, last time this year.
No, the last time I asked for anything. And if I don't follow your rules, I deserve to be locked up. I just want a chance to be back in the community, be with my family. Because if it's gonna be hard, my Social Security been cut off for a whole year. I haven't even got my check yet and then I gotta get my shot on Monday. If I don't, they can't give me my shot in here because it's a $10,000 shot. But I do need my shots. I have to go to CMH. I'm starting my new job next week at CMH building. Just give me this chance so I can do all this stuff. And if I promise you, this will be the last time I promise you anything.
Is this Groundhog Day? Because this is the same thing I hear.
But I'm telling you.
How many times have you told me this?
All right.
This
Let's
is
make
like
a deal.
the 4th time.
Let's make a deal.
Oh, well, okay. So we're gonna start negotiating.
Yeah, we're gonna.
Okay.
All right. So if
you realize this isn't a fair negotiation,
because you're the judge and I'm not.
Yeah.
Yeah.
Okay. As long as we understand that, go ahead.
All right. This would be a bigger deal. If I get any more trouble, you can lock me up for a whole another year. I just don't want to get in no more trouble.
I know, Mr. Scott.
I don't want to get. Listen,
Scott,
I don't
you
want to
don't
get in
wanna
no
do
more
that.
trouble, Your Honor.
I know you don't want to. You can't help it.
I can't help it, but I do need my shots. And if I don't get my shot, I can go to the mental hospital or anything. I don't want to.
Well,
can you
the
give me
Washington County Sheriff's Office will make
this is the
sure
last
you
chance
get your
I
shot.
have. No, they can't. It's $10,000. They can't pay for it because my insurance can't. My insurance can pay for it on the outs. And I'm getting my job back. Please let me go back home. I don't care if you put me on tether. I don't care if you put me on house confinement. I will do the right thing from now on. I won't get in
Both of those we tried.
Can we
They
try
didn't
one more
work.
time?
No, not today.
Well, can we try to let me out this time and then?
Not Tuesday.
But Mr. Simpson, if you don't let me out, I won't be able to shoot. I won't be able to show you I won't be able to show you my honest thing, man. Just Mr. Simpson, please just give me one
Mr.
chance.
Scott.
I don't want to be locked up.
Mr. Scott, I know you
I
don't.
don't want to be locked up, man. Every
But-
time I get locked up, somebody put their hands on me or do something to me in here.
Okay, Mr. Scott.
Yes,
listen to
sir.
me. We go through this every time.
But it's a new year.
And what?
It's a new year.
Listen to him.
I'm gonna listen to him. I'm just getting emotional. I'm sad right now.
I know. And all I'm going to tell you is, I won't say it won't happen ever, but not today.
Well, what am I supposed to do? I can't.
Just sit tight.
If you give me this chance, Your Honor, I promise you, listen, I promise you I'll do the right thing.
Say no.
I do the right thing from now on. Just one chance, Your Honor. You saying no, but in your heart, I know you really wanna give me a chance in your heart. Just give me a chance this time. I
I
promise.
appreciate you acknowledging that I have a heart.
I know you got a heart, but can you please just, Simpson, please just give me a chance this one time.
Okay, you can go to,
No,
Well, can I have a lower bond?
not today, Mr. Scott.
Well, my grandma's birthday is on the 24th.
today.
My brother's birthday on the 23rd. My sister's birthday on the 22nd.
You can go to deputies.
What am I supposed to do? I mean, I don't want to just sit in jail and rot.
You gotta sit tight, Mr. Scott. You can close the
My
file.
intention is not to have you rot in jail, but I'm not letting you out today.
So I'm not getting out no more.
Go to deputies.
Not today,
So when do I come back to court?
the 28th.
And then what?
We'll try.
I don't know.
You say that all the time. You don't know.
Whoa,
No,
really?
I'm not saying.
Seriously?
No, I'm not.
I think
like
you
that.
need to stop about now.
No, I'm saying like.
I think you need, Mr. Scott, you need to stop about now.
I'm sorry. I apologize. I don't want you. I mean, I don't want you to say that all the time. That's what I meant.
Okay,
That's what I meant.
I know.
But what? Well,
Okay, all right, go to deputies.
am I gonna get out ever? That's all.
Oh, eventually, yeah. Because we'll run out of time.
Huh?
Nothing.
Go.
All right, thank you.
All right, gotta go now. Let's go to deputies.
I wish.
We'll see what happens on 28.
You're in custody.
you do it.
What did I tell you?
Okay, then you're in custody, and then just.
What did I tell you?
Oh,
Yeah.
so, got it.
So,
I didn't want to let you know. All right.
Court recalls, okay. Garage, cooperate, don't mess up, because you do something here, then we're gonna have a problem. Okay. Why seriously? I don't know why you let that happen, Feaster. Court calls the case